Good evening. Welcome to the April 26, 2023 meeting of the Town of Southampton Conservation Board. In accordance with the Town Board's adoption of local law number 14 of 2022, the board's meetings are being held both in person at Town Hall and via video conference through Zoom webinar. The link to participate in this meeting via video conference can be found on the town's website at the Town Clerk's Agendas and Meetings portal. You can also watch the live stream video and submit written comments for the public record through the town website. If you are attending via Zoom and wish to speak during this meeting, then please click the raise hand icon. As a reminder to all applicants, agents, and members of the public who wish to speak at the meeting, please state your name and hamlet of residence for the record. Thank you. Now would you please join us as we salute the flag. I pledge allegiance
to the flag of the United States of America
and
to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
What is your pleasure on the minutes of April 12th, 2023?
Move to accept.
Second?
All in favor?
Aye.
Opposed? Public hearings, A021027, Morrison Feastness and Kathleen Cuomo Feastness.
For the applicants, Susanna Herman and consultants, 1319 North Sea Road, Southampton. At the last hearing, which I think was about 6 weeks ago, we presented our application for a new house at 132 Cold Spring Point Road. Just a reminder, this is the house that was approved by this board several years ago. And when we went to renew the permit, the wetlands line was reflagged, and now we're here applying for the same house, same location, same size. However, the wetlands line has changed. And the other significant difference is the sanitary system that we're proposing today is an IA system that is a shallow system. We no longer require a retaining wall. And at the last hearing, the board suggested that we should provide some floor plans and consider reducing the square footage of the proposed structure. So I've met with the property owners, and they've agreed to reduce the footprint of the house by 181 square feet, which brings us down from 1283 square foot for the footprint to 1102 square feet. The house would be 29 feet by 38 feet. They've also agreed to reduce the entry deck on the east side of the house. This one over here. We did have a much larger structure on that side. That was part of the previous approval. That's been reduced from 9 feet of decking to 6 feet of decking. So a 33% reduction. We've reduced the footprint, as I said, by 181 square feet, or about 15% reduction in the footprint of the house. Since the and I'll let Marty speak to his sketch as well. Since the last hearing, Marty has provided us with a sketch with his recommendations, which involve an even smaller house and rotating the proposed westerly deck, which is oriented in the north-south position. On our proposal, he's rotated that 90 degrees in order to achieve a slightly larger buffer on that side of the property. Doesn't work very well for the homeowners, however, because when you only have a narrow opening or connection between the deck and the house, there's not very good access to get out onto that deck. If it's not a large deck and there's no outdoor living space on this property, there's no yard, the entire property would be covered with native vegetation. that's already covenanted as part of the previous approval, the buffer and the fact that there would be no non-native landscaping on the property, would be all native landscaping. So the only outdoor space they have is this deck that's 29 by 15. And if the only entrance to that deck is only 15 feet wide, you've got to put your outdoor eating table and any chairs or anything that you're going to sit outside all in that space in a row. So every time you're walking to your table, you have to trip over your chairs or whatever. It's not a very convenient or safe layout, and they would much prefer to have the north-south orientation, as we're shown here, so that that's going to happen every time. So that when you exit the kitchen or the living room, you have your table in one space and your chairs in another space, and you're not tripping over them as you go out this way to try to enjoy some outdoor time. It's a family that really enjoys being outdoors. And as I said, it's the only place on the property that they will be able to spend time outside and enjoy the beautiful environment and waterfront views here. Just as a reminder, this family has owned the property for over 60 years. They've had the intention of building here for a long time, and for personal reasons got delayed and had to renew the permit. So at the last hearing, we said that we would work on a compromise footprint and try to reduce the house, and we've done some work on that. Marcin, the husband, is a architect, or trained as an architect. He's not certified, but he's come up with a floor plan that can work. It's not optimal. The original footprint worked better. It allowed them to have an office on the main floor, or den, so they could have a little separation between that and bedrooms. This reduces the bedroom count to 3. Whether it's 3 or 4 is the same septic system, but the reduction in the square footage of the house makes it such that we really can only fit 3 bedrooms. I think the reduction in the entry deck is significant, and I think the reduction in the square footage of the footprint of the house is significant as well.
Thank you, Susanna.
Good evening, Marty Shea, Chief Environmental Analyst for the town. As expressed at the prior hearing on this application, the applicant is seeking significant relief from the required minimum wetland construction and buffer setbacks. The required setbacks for a vacant property is 125 feet per building and 100 feet for a naturally vegetated buffer. At present, the applicant's plan calls for a setback for the construction of only 18 feet as compared to the required 125 feet. Acknowledging that this is a constrained lot, what Chapter 325 directs you to do when you review an application of this kind is to look at practicable alternatives. Now, practicable alternatives can include both increasing redesign of the development to increase wetland building setbacks, but as defined in the code, it also includes reducing the scale of the activity. My preliminary advisory report had made recommendations in terms of an alternative. I thought it would be beneficial to the applicant and to this board to put that on paper. So before you is a drawing dated April 25, 2023, which depicts an alternate plan for this site, which would reduce coverage and increase building setbacks and buffers. I had recommended early on, and consistent with this drawing, that the house size, notwithstanding the prior approval, be reduced to approximately 968 square feet, which is very consistent with the maximum allowable residential coverage by this board on the abutting lot to the east. Which is very similar to this lot, except that in that location, the house is even further away from the wetlands than in the case of this property. But I did try and look at that as a possible model for development of this property in the interest of ensuring consistency when these types of applications come before the board. As indicated by my drawing, I also recommended that the deck be reoriented. I did not ask that the westerly deck area be reduced, but I asked that it be reoriented in a west-east direction. And you can see the significant benefits that are accrued by doing that. Whereas the closest setback of the deck in the house under the applicant's plan is about 18 feet, under this plan, the house location remains the same, but the deck setback increases to 32 feet at its closest point from wetlands, and also allows for a significant expansion of the buffer in that along the westerly property line, the buffer is maximized at 40 feet. With regards to the deck access issues that the applicant spoke to me, it's, my own deck is a lot smaller than the deck that is proposed here, and we don't have any of those access issues. So the concerns of the applicant in that regard are somewhat unclear, and there are also not concerns that this board, that Chapter 325 directs this board to consider. This, again, is a very environmentally sensitive area. It's an area that's highly vulnerable to storm impacts and flooding. And one of the goals in increasing setbacks and buffers is also to better protect the house in the case of a hurricane or a significant storm event. So consistent with the directives of Chapter 325, my sketch would further decrease the coverage and ask the applicant to come forward with a redesign that further increases building setbacks and allows for a greater buffer. While the applicant has offered to landscape the remainder of the property with native vegetation, which is most beneficial to native insects and songbirds. Buffers are most areas of natural vegetation, and buffers are most functional in terms of wildlife habitat and filtration when they are parallel to the wetlands. So again, that's the reason why I recommended these design changes to increase the amount of buffer that's parallel to the wetlands on this property. Thank you.
Thank you, Marty.
I just wanted to add that the house layout that we have designed is ADA compliant. There is an expectation that one of the homeowners will likely be in a wheelchair at some point. And so they've designed everything according to that philosophy. And rotating the deck 90 degrees makes it more difficult, probably impossible, to have a table and chairs out there and also keep it wheelchair accessible. Also, with respect to the square footage of the house, because we're in a flood zone, we need to have the mechanical room on the first floor. So we have no basement, we have no garage, we have no outdoor shed or any storage, so we need some storage area as well. And also, obviously there's a staircase and an elevator is proposed as part of that footprint as well. So the mechanical room, the elevator, and storage take up some of the first floor, which is why we feel that the footprint of 1,102 square feet is reasonable. The house to the east, the adjacent property to the east, the footprint of that house is 1,006. And they have some outdoor space as well, and a 6-foot-high retaining wall around their sanitary system that has a patio on top of it. We would have really no outdoor space on this property, which is why a functional deck, I think, is the practicable alternative here.
Susanna, would you run by this problem with a 15 by 29 foot deck?
Why it's a problem?
Yes.
It's not a problem if it's oriented north-south, like we have here. This is actually the upstairs footprint. I'll show you the...
Is that deck elevated or what's
Yes.
the, okay, all right.
Yeah, the house is in a flood zone, so the first floor elevation would be 10, which is about 5 feet above natural grade. So, we need stairs to get up there. One thing that Ms. Cuomo also pointed out just today, which we need to consider, is we're going to need a walkway, probably an elevated walkway to connect to the boat basin and the dock. So we need to look at that as well. But yes, it's an elevated.
Well, let's look at Marty's drawing, where he's suggesting a deck that's 15 feet wide and 29 feet long.
Right. So if you look at the first floor plan, I don't know if everybody got those things.
Yes, we did.
So the kitchen and dining, indoor dining are on the,
Can you stand at the podium, please?
You're being watched.
it's like God is speaking. If you look at the western half of the house, you have the kitchen and the indoor dining space here. Access typically from a house out to your outdoor deck would be that out those sliders to that deck that you would access off the west side of the house. And typically you would use that space to have some lounge chairs and a picnic table, an outdoor dining table with some chairs around it. If it's oriented this way, you can access the chairs, you can access the table fairly easily. If you turn it 90 degrees, as in Marty's sketch, every time you want to access either table or chairs or the lounge chairs, you have to go past the other, which makes it more difficult. You've got chair legs sticking out in the walkway. It's a fairly narrow passageway once you put a table in that space to get by that. 15 feet is not that wide for that space plus walking access or wheelchair access past it.
When I look at that space, if I wanted to put a picnic table there, I would have a built-in area for a bench on either the south or the north side, with a table that goes right there, and then corresponding chairs or a bench on the other side, which leaves several feet in addition to get around on one side or the other. One of the problems we have in this application is that the setback from the wetland is about 14% what the code recommends. So we have to get creative, and we have to figure out how to do things in a constrained area, which by its nature is gonna mean we don't get everything we want. Because if you need all those things, this is the wrong lot to do it on. And the wetland line has already expanded into the property. Likely, it has not finished expanding into the property. So we're here between a rock and a hard place, trying to figure out how to make something work, which is very difficult. So getting a deck, I think, is a win. The details of the deck is just icing on the cake. In other words, I'm not sympathetic. Sorry.
Well, if you're gonna build a deck, you would wanna build a deck that works for the family that's going to use it, so.
Well, I would say the family has to work with the space that they're given.
Okay.
What's the difference in the buffer between one orientation and the other? What's the increase in buffer size available to you?
18 to 32.
18 to 32?
That's the setback difference.
Okay.
Although if you orient it north-south as we proposed, you would have more buffer area on the side as opposed to on the south side of it.
Okay.
Instead of below, you would have more buffer on the side.
Okay.
And the decrease or increase in the square footage that we're talking about of the house does not impact the wetland setback. It's basically the same setback, whether we're talking about 1,100 square feet or less than 1,000. We're talking about the same dimension here.
Susanna, would you know how high the pilings are?
How high the pilings are? You mean above grade?
Yeah, how much is that gonna raise the house?
The proposed first floor elevation is 10, and I believe the grade is around 5. Let me double check. Obviously, it's not completely flat. It varies from 4.2, 3.2. Underneath the house is 3.3. So actually, it would be closer to 6 or 7 feet above grade.
Thank you. I have a question for Marty. You want that?
Yes.
Could you elaborate a little bit in terms of with the setbacks that we're looking for if the house was on flat land as opposed to on pilings? Do you see any difference?
Well, typically today, when homes are elevated on pilings, the landowners elect to use that area below the house, below the base flood elevation, for storage and other uses. So today, while the elevation of the house on pilings, of course, is beneficial with regards to better protecting the house from flooding and storm damage, there's not a very significant difference in the degree of impact. You know, it's a little bit different when you're looking at a light penetrable decked catwalk or something like that, because then there's an ability for natural vegetation to grow under that. There's no ability for natural vegetation to grow under a house that's only elevated about 7 feet above the ground. So there's not. The issue with a lot like this is really the coverage, and you know, Chapter 325 directs us, by way of the definition of practicable alternatives, to look at not only setbacks but the scale of the activity. So the best way to reduce setbacks on a constrained property like this is to reduce the coverage, whether that be elevator on pilings or, if it was permitted, at grade. I had early on expressed that the applicant might want to consider a modern house with a flat roof, and then a significant portion of the roof could be dedicated to deck space as well. But the applicant apparently has no interest in looking at that design option. With regards to the comments that were made about buffers, while the applicant was right that at its closest point, the deck on my drawing would be 32 rather than 18 feet from wetlands. When you go to the western property line, the buffer further expands to about 40 feet. The applicant indicated that if you orient the deck in a north-south direction, there might be an ability to have a strip of buffer along that westerly lot line. But narrow strips of buffer are less beneficial than blocks of buffers that are parallel to the wetlands. I hope I answered your question. All right,
Thank you.
thank you.
Suzanne, are you expecting to use the area underneath the deck for storage? Or would it be open? You said it's like 5 feet above grade, so.
Well, you've got, the floor is gonna be about 7 feet above grade. But
7.
underneath that, you've got your girders and the supports that the piling's attached to. So the open space is not like a walkable space. You're gonna have like
No, but you're
5
not gonna use it underneath for storage.
I
It's
mean,
gonna
you
be
could-
open to the, I mean, the ground is gonna be
Yeah,
unutilized.
it'll be open. I mean, there may be some lattice around the outside, but it's gonna be an open piling foundation.
Okay, so you're not using it for storage.
I mean, you
Okay,
could
so-
slide some kayaks under there, but I don't think it would be anything more than that.
No, I just wasn't sure if there's a possibility of planting beach grass underneath it. It's not gonna be light reaching it enough where it's gonna be
I
beneficial.
don't think, uh, we
Because
may
if I
put,
knew you weren't gonna use that for any kind of activity, and it was gonna be open to possibly planting even beach grass there if the light is gonna get to it,
I
mean,
don't-
it's-
I
would
don't
consider
think you're
that as
gonna,
something.
I don't know if you would get light underneath the
Okay.
house. Maybe underneath
I'm-
the
I'm
deck.
trying to be
yeah.
creative as far as.
The-
I'm willing to plant beach grass under my deck, 100%, if it would help the environment.
Yeah, I mean, that is something we've talked about, planting it, underneath the deck or.
Just the fact that it's not going to be trampled on and whatnot would be something I'd consider. I just
Yeah.
wanted to find out what your use was.
The underneath the house may be required for drainage. I've talked to the engineer about the possibility of actually putting the dry wells underneath the house,
Mhm.
just to,
But-
because you can't put them too close to the septic because of health department regulations. And everything else is buffer or natural vegetation, so we don't have a whole lot of space for drainage. And I think at least some dry wells may be underneath the house, which is a possibility.
Yeah, but since the deck was a hot button topic tonight, I just wanted to see
Yeah,
what we can
underneath
do
the
to
deck.
rationalize one versus the other. Okay.
Yeah, underneath the deck could be planted
Okay.
with beach grass.
Okay.
Suzanne, can you talk about dividing?
Yeah, I'm not sure whether or not it's clear why the deck in this orientation is so much more convenient for the homeowners. From, stay at the podium, or I'm gonna get in trouble again. From the dining room and kitchen area, if you would have 3 doors here. So you could go out this door to the table, which would take up about 15 by 15 with the table and chairs. You could go out this door to get to chairs. So you're connecting the indoors to the outdoors more, which makes it much more accessible and easy to use. And that way you're not having to pass by the table to get to the chairs or to get to your access to the water, which you're going to have to go that way as well, because the path and the ramp to the boat basin is on that side of the property as well. So not only is it a space for outdoor dining, outdoor sitting, if you want to put a couple lawn chairs, you also need to get out this direction in order to access the boat basin and that path.
Any other new information or new questions, or we're just gonna
Well-
negotiate what's going on here?
I've said my thoughts on the deck. As for the house, there's not a whole lot of difference between 968, which is what Marty's saying, and your
1,100, it's just
11,
over 100 square
yeah.
feet.
1,102.
Yeah.
But I imagine the difference is required because of the setback from the property line, so that you can't, you have to shrink the house in order to get the deck over there. But I look at this whole area and more than just this lot, because we've had several applications in this general area, and they're all that I can remember are very highly constrained. And I look at chapter 325, section 9, 9D, and we go through these tests to see how we can make something work, and it's hard to figure all these things out because it's so short of the recommended setbacks, both in terms of buffers and in terms of building setbacks. So I think for you to get any house on here is a win for you.
Well, it is a single and separate building lot that the family's owned for 60 years.
It is, yes, I recognize that. And it's unfortunate that it's taken this long to do this, and then all these restrictions, and the law came in, and if they had built this 50 years ago, we wouldn't even be before a board.
Yeah, and if you look at the property next door to the east, which got approval several years ago, now the wetlands have come up on that property, and even though it was a 40-foot setback when it was approved, the wetlands are just as close to that house today as the wetlands would be to the house that we're proposing. So we're not creating a situation that's worse than what's next door. And they're very similar lots. We're proposing very similar sized.
It's because of those neighboring houses that the legal people say you gotta look at that and do something in concert with what's around you. I think either of these proposals will do that, except Marty's gives a little more buffer and a little more setback. And that's why, in my thinking, the scale is weighted towards Marty's drawing rather than yours. Unless you can come up with some compelling reason why we don't need, or should have even a less buffer. Even with Marty's sketch, it's way short of what the law recommends.
When you are leaning towards Marty's sketch, are you talking about just the deck orientation, or are you talking about the 1,100 square feet versus the 968?
I'm talking about the whole page,
Okay,
because
you
I don't,
mentioned you didn't see a big difference between the square footage, you
Yeah.
were looking more at the deck.
yeah, because I don't know that that deck and Suzanne's house will fit here with the setbacks, zoning setbacks from the side yard.
Would the homeowner, after consultation with yourself, consider reducing the house by a foot as well as the deck by a foot?
We may have to talk about that and weigh the size. I think the house size is very important. If we go smaller than what we're proposing here, it becomes very difficult to do an ADA house that will fit the elevator and will fit the mechanical space, etc. And so there may be some give and take between the deck and the house, but I'd have to talk to them. We'd have to work on, work that out on paper. So
That would be my
not-
suggestion,
Yeah,
because we seem to be at a standstill here.
I think that's a very good suggestion. So we'll talk about that. We'll hold this over to the next available date, if that's possible.
I'm gonna see if there's anyone in the public who wants to speak. Is there anyone in the public who'd like to speak in this application? And Kevin, anybody on Zoom?
No one on Zoom.
Tom, what date do we have available?
Well, we're getting into a full period of time, but if it's something quick, I don't wanna hold up something that
I-
seems like it's only a one
I think we're
item.
we're honing in on,
If it's only a one or two item checklist, I don't see holding them over until June. And some of the applications in May are double-digit postponements that I'm not.
how much in a rush are you? Do you wanna wait till June or try to get it done sooner?
June?
What's
You'd rather
the
have May.
date?
What is the date
Well-
in May?
Memorial Day.
We
May
have,
10th or 24th. 24th has 4. May 10th has 4. June 14th has 3, and June 28th has 1. Depends on how much time you think you need to get drawings and whatnot together, and how much of time you think you need to plead your case on that
I
day.
think May 24th will work, and I think we'll have a great plan that everyone will be very happy with, except maybe Marty Shea.
If it's quick, we have 3 new out of the 4, so, and the one
Okay.
hasn't been discussed, so. Been a lot of postponements, but hasn't been
This guy
discussed,
here
so.
probably gonna get postponed again.
Well, I know, that's why I said
Okay.
that, some of them have been postponed a long time, but the 24th is probably not the best day
this
for
is
us,
quick.
but if it's gonna be
Yeah.
quick, I don't wanna keep holding people over.
would you be ready by May 10th?
My husband will not be in the country.
Yeah, we need
Okay.
Barson to be in the
Okay.
country.
Okay.
Even if he's not here, he's very involved in the design
Okay.
process and has, needs to be involved.
If you
so.
think it can be a quick in and out with negotiating with the homeowner and
Mhm.
talking it over with our area
Mhm.
to make it expeditious,
Except May 24th is the busiest day we have.
well, then it's gotta be June.
Can we do
14th.
June 14th instead?
Okay, June 14th
Okay.
will work.
Okay.
We have 3, let's not put any more on than this,
Okay.
and,
If these two are together,
Motion to,
and this is quick.
motion to adjourn to June 14th?
Second.
All in favor?
Aye.
Opposed?
Thank you, committee.
Thank you.
Thank you.
K021094, 51 MPL LLC.
It's going to be, landowner is going to appear by Zoom. His name
At a
is
meeting- at a
Jason
meeting.
Rosenfeld.
Okay. So Kevin, I'm told the landowner on this application is going to be on Zoom. Is he there yet?
What's his name?
His name is Jason Rosenfeld.
Got him.
And he's on.
Hello, Jason.
I'm on. Greetings.
Okay, you're on. Would you like to talk about your application?
I don't have anything to say unless Marty wants me to say something.
We had a discussion at the last meeting, and the architect was here, if the board recalls, and there were some issues we were trying to get answers to. And now, Marty, you do have a sketch, which is very different than that. Maybe if you could introduce that sketch, and then that can prompt some questions.
Good evening, I'm Marty Shea, Chief Environmental Analyst for the town. This is a continuation of a hearing for a very constrained lot at contains and abuts town and state regulated freshwater wetlands. The initial plan for this property had called for retention of the existing home, construction of a second-story addition on the dwelling, construction of a northerly 1- or 2-story addition, as well as building of a swimming pool, with the swimming pool to be in very close proximity to the wetlands. That application had generated significant concerns. And so, consistent with the directives of Chapter 325, I looked to see whether or not an alternate plan could be put forward that maximized wetland building setbacks and buffers. I had a great opportunity to meet with the landowner. We had a very productive meeting. The meeting was beneficial as it gave me a much better understanding of the wants and needs of the applicant in terms of the expanded home. As a consequence of such meeting, and consistent with discussion, I prepared a drawing, a alternate plan for this site. That drawing is dated April 12, 2023. At the first hearing, there was some discussion as to whether or not it might be preferable to demolish the existing home and construct a new home. But having met with Mr. Rosenfeld, we felt that the best approach was to retain the existing home and to go forward with the plans for a building of a second-floor addition on that home. Much of our discussion centered on other similar lots that have come before this board on Mill Pond Lane. And we looked at those designs to see how we could go forward with a home expansion while at the same time to integrate a swimming pool in a manner generally consistent with what this board has approved on other similar neighboring lots. So the drawing that is before you, again, what it shows is the existing dwelling would be retained. A new complete second floor addition would be built. The former plan for a northerly residential addition has been abandoned. And the plan integrates a swimming pool and patio area in a manner pretty consistent with what this board has approved on area lots. Plan, of course, provides for an upgraded septic system for installation of an IA. It maximizes parallel, naturally vegetated buffers adjacent to the wetlands. And it also calls for native landscaping of some of the remaining disturbed areas landward of such covenanted buffers. The proposal integrates a pervious drive to allow for real good rainwater infiltration and to lessen runoff. After I provided the drawing to the applicant, we had a lot of emailed discussions back and forth. He had a lot of initial questions. And in the end, he has decided that this plan works for him And I've assured him that this plan is not only consistent with what was allowed on similar lots, but meets the standards for wetland permit issuance, in that it maximizes buffers, it maximizes setbacks, it upgrades the sanitary system, and sets aside sufficient area in order to allow for on-site drainage, while providing the opportunity to landscape some of the remaining disturbance areas, such as the land atop the IA, with native plants. So I think acknowledging the desires of the applicant in terms of future home renovations and expansion, and recognizing those exterior uses that are most important to the applicant, and also recognizing that the applicant has significantly reduced the scale of the initial proposal for expansion of the home. I think this plan works well for the site. The applicant has agreed to go forward with this plan. So that being said, I think we can look to close the hearing tonight. Thank you.
Thank you, Marty.
Jason, you're in agreement with Marty's plan then?
Yes, thank you. I concur with Marty's description of our interaction, which has been terrific, and the very useful plan that he's, sort of draft concept that he's put forward. And I hope that we can get sort of conditional approval, and then we can work together to make it, as it needs to be.
Thank you.
Any other questions?
No.
Is there anyone in the public who'd like to speak in this application? Kevin, is there anyone on Zoom?
No one on Zoom.
Is there a motion to close the hearing?
Motion to close the public hearing.
Second.
All in favor?
Aye.
Opposed? Thank you, Jason.
Thank you. Thank you for your service, Marty. Thank you, George.
A 022044, Michael Hausman. This is an application where we really didn't ask you guys to do anything.
Yes, you did.
Why are they here? Of course we did.
Oh, okay. All right, we did.
Yeah, you did.
Well, we did ask our attorney to do some things.
Yes. Would you like me to go first?
No, go ahead and speak.
Not opening that.
You do need to open that because this is in there.
Yeah, we have some drainage.
Good evening, Daphne.
Good evening, Daphne Vaughn, Surfside Environmental Planning. I'm here tonight with
We
the
had some things
Hausmans.
around the pool to do.
There is a submission in the file there dated April 17th with a revised buffer plan, which is what the board asked for before we left the last
Yeah,
meeting.
I
For
remember
us
that now.
to revisit
Yeah.
our last buffer and do some further expansion.
Thank you.
So we went back to the drawing board. I don't know if that was me. And we did what you asked. We have come now within about 1,000 square feet of Marty's original buffer sketch. It's actually slightly less than that if you take into account the wetland access path. So it would be about 750 square foot difference of planted area between Marty's sketch and our proposed buffer. We've done significant expansion on the Reeves Bay side of the property, which is where the waterfront is. And we have done some minor expansion in the back of the property to, I should probably open my notes, I'm just talking off the cuff.
The proposed buffer takes up 29.23% of the upland portion of the property. And they've expanded it by over 1,700 feet from the last sketch. And I know when we left, Michael Hausman had said that he would look into expanding it by about 1,000 square feet. And the board had said that that would more than likely be acceptable. So he went above and beyond that with Arena, his wife, and they've come up with an additional 1,700 square feet of buffer. They diminished the area around the pool from 6 feet to a 4-foot envelope, and they've left themselves an 8-foot passage in front of the house here. And then they've got their garden area and chicken area that we've discussed at the past few hearings. So I believe that this exceeds what the board was looking for at the last meeting as far as the buffer is concerned. And otherwise, we adjourned because Ms. Doyle had some paperwork to review from Mr. Walsh.
Thank you.
Thank you, Daphne.
Go ahead, Mark.
Good evening, Marty Shea, Chief Environmental Analyst for the town. While I do appreciate the applicant has come forward with an expanded buffer area, there is yet some concern regarding the size of the buffer between the chicken run area and the wetlands. Chicken yards produce a lot of nitrogen. When you have significant nitrogen inputs into wetlands, that can result in a change in the ecology, the acidity, the pH, and that nitrogen can also enter the surface and groundwaters. So while I would have preferred that the applicant focus more on expanding the buffer in the chicken yard area, in response to the board's request, the applicant's plan does offer considerably more buffer than the prior plan. So I thank the applicant for that. I just wanted to make a final brief comment. I know there was a lot of discussion about the amount of fill that will be deposited on this site. One of the things that came out of the last hearing is that one of the reasons for the fill is to elevate an intended workshop, a studio area beneath the base flood elevation, with the hopes that when that area is utilized as a work studio, the risk of flooding and flood damage is reduced. My office had an opportunity to talk to the building division about the plans for the elevated work studio under the required finished first floor elevation, and the building division advised that while that might be allowed, the applicant needs to know that typically in these cases that storage or work area can only have one light fixture and one outlet, and typically that would be mounted on the ceiling beneath the finished first floor. So, the plans that were put forward before this board that shows pretty expansive work studio areas, I'm not sure how functional they're going to be, considering the building division's restrictions on outlets, electric outlets, and lighting. under the finished first floor in flood zone. So the applicant should be aware of that in the event that these plans are approved and they go forward with that design. The reason some lighting and at least one outlet is allowed below is because even if those areas are only being used for storage areas and not for living areas, in order to ensure safety in terms of access, you need some kind of lighting. But obviously, the intent of the requirements is to make sure that you don't have a situation where the electric wiring and utilities are flooded, resulting in issues with regards to the dwelling. So I just wanted to make sure that the applicant was aware of the restrictions on outlets and lighting in that intended elevated work studio area, because that may have an impact on his future plans for use of that area. I know the applicant had expressed that, that he would likely have a lot of tools in that area, and so I just wanted to make the applicant aware of that. Thank you.
Thank you, Warren.
Kelly Doyle, Assistant Town Attorney. At the last hearing, there were various issues that were raised with regard to the history of the applicant's property, how it evolved to the present size and configuration, covenants and restrictions, also conditions of a DEC order on consent. So I just want to address those jurisdictional and legal issues. The first issue was the merging of the two lots and whether that was an improper subdivision. I did find, according to the ZBA records, the lots that were previously identified as tax map numbers 900, 147-2-32 and 34.1, they were merged pursuant to a ZBA decision. The variance relief was granted to a prior owner in order to leave the existing, what's now existing, pool and pool deck. They were actually constructed across two lots. I believe they were owned by husband and wife. And they had intended to merge them, but they never did, and a CO was issued, and then the ZBA said, well, you have to merge those two lots. So that's what happened there. The ZBA didn't say anything about planning board approval in their decision, so I don't know if that was required or not. In the event that planning board approval is required, I would imagine that the planning board would approve the merging of the lots because the ZBA required that quite some time ago. And another thing that the board could do, if you are so inclined to grant any approvals, you could condition your approval upon the applicant providing proof as to whether they need planning board approval, they don't need planning board approval, or the planning board would waive approval. So you could make that a condition if you wanted to. But I don't see that particular issue as preventing the board from moving forward. And then the second issue has to do with a certificate of abandonment. I have a copy of that. On its face, the certificate of abandonment appears to be properly recorded. There's a recording page from the Suffolk County Clerk's Office. There's a received stamp from the Town Assessor's Office. There's a certification, a surveyor statement, a description. And the abandonment was approved by the town's sole assessor and the town's superintendent of highways. And this particular board does not have any jurisdiction to approve or disapprove or review certificates of abandonment. So you really have to rely on what appears to be a properly recorded certificate. And again, it was approved by the town assessor and the highway superintendent, so you're kind of bound to rely on that. As to the private covenants, first I just want to make sure there's a distinction between private covenants and covenants that are recorded as a condition of a town approval, planning board, ZBA, or this board. If there's a covenant that's recorded as a condition of a town approval, then of course, the board or department that required that, they can interpret that covenant and the town can enforce it. If there's a private covenant, then generally the town, has no authority to enforce that. And the case law that I found in New York, the general rule is that something that you can do under a town ordinance and a private covenant, those are different matters, because one is a legislative act and the other is a private agreement. And private covenants are generally, those are considered private property rights. In order to enforce that, they would have to be enforced through a private action between the parties that are allegedly asserting those rights and violating those rights. So essentially the issuance of a permit for a use that's allowed by a town ordinance usually can't be denied because it would be in violation of a restrictive covenant. Another issue that we have is restrictive covenants can only be enforced when the intention is clear and they're not offensive to public policy. That's usually something that needs to be decided by a court. It's not the conservation board really can't determine whether something is offensive to public policy or whether it's reasonable. It's just not for this board to decide. And with that being said, although the town cannot enforce private covenants, we do ask for applicants to provide copies of covenants to show easements and rights of way. If there is something that's very clear and we can see that there are clearly defined rights, then the Environment Division staff and this board usually try to work with the applicant to come up with something that's not going to interfere with the rights of others, because if something happens in the future, then they would have to come back and amend their plans. So if there's something that's very clear, you try to work with that. So right here with these, this application, the instrument, there's a 1952 instrument, which it's been alleged that there's at least one or more neighbors have a right-of-way over Fanning Road and Pearson Road. So there was a portion of Fanning and Pearson Road that was abandoned. And again, we talked about the certificate of abandonment, so we're bound by that. But there are still some portions hold this up. There are still some portions of Pearson Road and Fanning Road, Pearson Road here, that this project will not impact those portions of the road. So there's that. And then the right to use the beach, that was the second thing that was in that 1952 instrument. I believe that the beach that we're talking about is the beach over here. This is a separate lot. This is 47 Pearson Road. So that's not the subject of this application. So I don't think that this project would impact their right to use a beach on a separate lot over here. And if, the applicant should know that if anything does come up in the future, they would have to come back to this board, to modify plans. If it got to the point where there was a court order addressing any of this. The last issue was an order on consent. It was issued by the DEC. This board has no jurisdiction to enforce those conditions in that order, and the property owner will need DEC approval for this project. So when they go to the DEC, if anything comes up there and they have to modify the plans, then they would have to come back to this board for approval for any modifications. Same would be with the health department as well. So, there were definitely issues here that warranted review for sure. But this particular board's jurisdiction is limited to Chapter 325. And I don't see anything in the town code or the law that would require a stay of the board's decision at this point in time. And again, it is the applicant's responsibility to comply with, the laws and regulations of other boards with other jurisdiction. And, as I noted, if anything changes because of health department or DEC, then the applicant would have to come back for approval for the revised plans.
Thank you,
Any
Kelly.
questions?
Thank you, Kelly.
Hi. With regard to Marty's comments about the spaces underneath the house, this is a FEMA flood zone AE8, so it's my understanding that anything above elevation 10, which would be 3 feet above the floor in these spaces, would be FEMA compliant, so I'm not sure why outlets that would be, say, at this level or lights would be an issue. I don't know. But that's for the building department, and that's an issue that we can certainly discuss with them when that time comes. Otherwise, what are your thoughts on our plan?
I think you did a nice job.
Yeah,
We
me
asked for
too.
1,000 feet, and you went above that. Thank you.
Question to the applicant. How many chickens and turkeys do you
You're
have?
speaking to a farmer.
Do you have now? And do you plan on expanding that?
We need a microphone, sorry.
Okay. Hi, I'm Michael Hausman, a homeowner. We lost one, sadly, to a neighbor's dog. So we now have 9 chickens and 3 turkeys, and we think we're going to get 6 more. And I think that's going to be it.
6 more what?
Chickens.
Okay.
We committed to 6 more chickens, yeah. So,
Do you
it's not-
provide a roost for them to go on at night?
yes.
Are they all hens?
Yeah, they're hens, yeah.
Is
And
that,
we,
You usually take care of their droppings?
yes,
Okay.
is that roost under some kind of
yes,
covering?
yes,
Okay.
yeah.
Uh,
It's a coop, arena house.
It's a coop arena houseman that Michael built. It's a duplex condo where they have separate quarters for the chickens and separate quarters for the turkeys, just so peace is restored sometimes. There's a downstairs area where they can roam and they're safe at night or when they wake up until we let them out. And then there's an attached run, which is completely enclosed, which is where they were staying when we left, and then somebody came and locked them up.
And this, so, to Marty's comment, I mean, I'm sensitive to that because we we love the water and we fish and everything, but all of that is being moved much further away from the wetlands than it is right now. So.
The reason I ask those questions is because chickens typically do fill up with excrement the area underneath the roost. At nighttime is when they seem to discharge much.
We
And-
collect that.
and
collect-
being-
We collect that.
And
Yeah,
we
being
live in the
under
gardens.
a roof means that it's not subject to rainwater washing that nitrogen away. If you collect it and dispose of it in some way, that helps to mitigate the potential negative impacts of high nitrogen.
There's a circle of life that happens where I collect the poop and I dry it and I put it back into the gardens. So at no
Okay.
point is it touching the ground from the coop area.
And the gardens are raised beds.
And for those few chickens, there's somewhat limited what they can produce anyway.
Yeah, and I think that it's a reasonable number of chickens. It's not a poultry business. There are
Well,
pets.
that's a lot of chickens just for a couple. Because they.
The neighbors really enjoy the eggs.
Okay.
Thank you.
All right, anybody else that wants to come on?
Otherwise, I'd like to get this going.
Is there anyone in the public who'd like to speak in this application? Mike?
2 hours, please.
Let's waste some more time.
Hi, I'm Candace Huffine, 20 Pearson. I just want to speak about the chickens since we're on the topic, instead of coming back at the end of the night about it. Yes, they are contained and they have a roost, and in this potential plan, they have a run that would be enclosed. I personally have questions, so hopefully this is a place I can ask questions. Currently, which is a part of our problem with this access to the beach that you speak of, currently the housemans, which Mr. Walsh will speak about, are fencing off access to the public park space that Suffolk County owns, which is the beach in question. They're fencing it off, and their chickens are free range into your public park space, which runs into the water. So all of the excrement and things that you're concerned about are happening on this lot as well, because they roam the entire neighborhood. So that lot subsequently is getting ruined as well, or your wetlands are being compromised because we've been blocked off access to get to this park space. That is now another extension of their property, and the chickens free range over there. So I'm just wondering if this is a concern of the board, as it is for myself, what is the plan that's been put into place to contain them fully and get us our access back to the beach, to the park space that is public to the entire community? This is what I'm curious about. So this question I have, if that's something that you guys would like to pursue further, I just need you to know, like, you guys own that space, so its conservation is very much a part of this conversation as well. Because he's blending the two spaces. They're just literally the chickens are crossing the road, and they're going and using that as their,
Just one, that one right there, that is county owned?
yes.
Yeah,
It's a public, it has a fence on it, says it's a Suffolk County park space.
okay.
And then the other backside on Fanning is also
That-
county owned, but that's a preserve.
I think that's town over there.
Yes, it is.
Yeah, town there and county there.
Yeah, okay, yeah. So that's something also that if you're inquiring about their
Could you
husbandry, then that needs to
just
be
use your
addressed.
finger and point very specifically to that precise area that you're saying is blocked off and needs to
Right,
be
so
opened up?
this is my house here. This is Pearson Road, a throughway. And your lot starts, I guess, over here. There's one small gate and 2 large gates that can open. It's being blocked before that.
It's being blocked on the Pearson Road area of the.
There's a fence that's going across Pearson Road.
Okay.
I remember one gate that
A
opened.
double gate, yeah, and then they open it onto their space and let everyone free, except for the people, the humans.
The gate is on
But that gate is.
town property or it's their property? It's a town
Town.
property.
Town, this is a road that goes all the way
Town.
through, so technically if this was owned by anybody else, this would be a driveway into someone's home, but it's owned by the county. So this is a road, and then this is their side, and then this is the other side, but they've blocked it here, opened the double gates, and used the whole thing.
Okay.
Something to think about when it comes to inquiring about the
Well,
containment.
if you wanted to get down to the beach from there, how would you do that?
Currently, the public park space is available for going down to the beach.
And you can access that.
I have to lift a makeshift fence that the housemans have made, which I nearly broke my finger on the other day. I have to open and close it. It's on, I don't know, it's wire, and it's in metal stakes in the ground.
Is that on their property?
It starts on their property and crosses the road and connects to the public gates.
So part of it is not on their property?
And it just blocks everything off, so it makes this piece of property obvious. He's just utilizing the space and taking something that's not his, and it limits our access to it, almost makes it nearly impossible. I'm not gonna mess with somebody else's strange metal fence in order to go see the sunset. I've already injured myself on it once. And the reason why I bring it up is because you did mention the chickens, and they block it off, open the double gates, and everyone roams free. So if it's a concern about their access to the water channels, then that's something to think about.
Thank you.
I didn't plan on speaking, sorry, but I just wanted to not, I think we get so, when I come up at the end of the night, I've already like forgotten all the topics that are happening in real time that I want to speak on, so I wanted to bring that up, but I'll leave it to Mr. Welch now. Thank you.
Would you like me to respond to that?
Sure.
Yeah.
Okay. So, there was a split rail fence on the border of the Suffolk County property, which is on the other side of Pearson Road from our house, but most of the fence has rotted and fallen down. There's a section with these two big swinging gates, and there's also a small gate. There's a construction project across the street from us. They're building a two-story house. And I asked the contractor, because the chickens were roaming over there, and I asked the contractor to put a fence around the property, and he didn't do it. So I ran a fence across the front of our property, on our property line. It's metal stakes with like plastic. It's like a plastic fence, you know, like a, I don't know what you call it.
Green
Some-
mesh.
Excuse me?
Green mesh.
Green mesh plastic, right? So I ran that across our property line, and then I angled it across the part of Pearson Road that we don't own, and I put it right up to the double swinging gates because I could get an extra 20 feet of protection from our chickens to go into the construction site. I did leave the small gate, which is for people to go in and out of the park. That is accessible from the road. I didn't block it. I'd be happy to move the whole fence onto our property. End of story. I'll do it tomorrow. I'll do it tonight.
Okay,
Totally happy to move it.
thank you.
But I was just trying to, keep them out of the construction.
Mike?
Hey, Mr. Chairman, members of the board, Michael G. Walsh, 860 Montauk Highway 4. Candace Fine, she's the next door neighbor to the applicant. We were here twice before. What I'm hearing this evening is we have to go knock on some other doors, which we fully intend to do. The planning board, the zoning administrator, the building inspector, and I guess the ZBA. I do have in the file, I think it was my last letter, a very good graphic that outlines the area that was abandoned and which essentially blocks legal access to this beachfront parcel that was made part of the subdivision, access to the beachfront parcel. So if anyone wants to explore exactly where that is, it's in the record. Number one. Number two, I sat here tonight and I listened to two prior cases. That Cuomo case on Cold Spring Pond, and then the Mill Pond case, Mr. Rosenfeld, I think he was. And I heard Marty refer to the practical difficulties, the practical alternatives test. Chairman referred to 325.9D, and the term reduce the scope of the project, reduce the scope or size of the project, was bandied about during the course of those prior applications. We put another letter in today. It's got an exhibit. If it's possible, we could put that up on the screen. What we did was we went around the neighborhood and we measured the structural footprint of the improvements on all the lots in the neighborhood. 1, 2, 3, 4, 5, 6 lots. And we went to the assessor's records, looked at the plans that have been filed with you, and what we determined was that the property before you is proposing a structural coverage footprint that is 300% larger than the average in the neighborhood. If you look at this graphic, you'll see 24 Pearson Road, which is before you. The existing structural coverage is about 3,700 square feet. The proposed is 6,348. Then you go around the block, 27 Pearson Road, it's a bungalow type house, 932 square feet. 21 is 2,442 square feet. 15 Pearson is 695. 18 Pearson is 1,995. And my client's house, 20 Pearson, is 2,082 square feet structural coverage. What I have not seen on this application although I saw it the 2 prior applications and many, many, many dozens of applications before this one, the Houseman application. What I have not seen is a reduction of 1 square foot of structural coverage since its application was filed. Things have been moved around, the board, things have been, and I just heard a comment that that's not true. And if it's not true, then maybe someone should mathematically prove it out by using the documents that have been filed to show us that the Houseman residence is not approximately 300% larger in structural coverage, the entire property, including the pool and the deck, 300% larger than any of the properties in the neighborhood. What's not happened is the practical alternatives requirement has not been applied to this property. 329D has not been applied to this property. There's been no suggestion that there should be a scaling down of the application. And I have dozens, not 1, 2, 3, 4, or 5, dozens of examples where this board has imposed that requirement on each and every applicant that was before your board. Number one. Number two, let's talk about these covenants and restrictions and what happens when these subdivision covenants and restrictions or a subdivision is somehow amended. Tomorrow, before the planning board, tomorrow, Thursday, in fact, there are 2 matters before the planning board where covenants are going to be discussed before the planning board and whether or not those covenants should be amended. Typically what the planning board does is they give notice to the people in the subdivision. Why do they do that? Because if you're going to lose your access to a beach that's part of your deed, where are we here? Here we are. If you're going to lose access to the beachfront that's part of your deed, part of the subdivision scheme, and you're going to abandon a road that eliminates legal access, I know your board does not have jurisdiction. I know that. I'm aware of that. You're a wetlands board. But I just want the board to know for future cases, if you do that and you're going to abandon roads and you're taking away legal access to a beachfront parcel that the subdivision lot owners have a right to use and a right to access by abandoning the road and annexing it and making it part of your deeded lot, you've got to go to the planning board, no doubt about it, and we're going to make a visit there. So I suspect we will be back here. I suspect we will be knocking on the doors of other agencies, other tribunals, and whatever we have to do. But I think what we have here, we have a situation where in effect what's happened here by virtue of the owners of the property, not necessarily Mr. Houseman, but certainly his predecessors, and then when he filed the abandonment certificate, because I believe it was done by this applicant, is you've created a situation where you've permitted the creation of a lot that apparently permits your board to approve a structural footprint on a lot that's 300% larger than the average in the neighborhood. I can't believe for a minute that that's the result that was envisioned by the drafters of 325. And I submit to you that there is more than enough precedent to convince you of that if you go back and you read those decisions. With that, that's all we have to say this evening. As I said, we'll be knocking on their doors, going to other agencies, and I suspect we will be back here. Because we don't make these suggestions lightly. We don't put these things in the record just because we have nothing else to talk about. We think that these are substantial issues, and it results in this project. If someone wants to do the math and convince me that this property is not 300% larger than the average structural coverage in the neighborhood, go right ahead. I don't think you're going to be able to do it. Thank you very much.
Thank you, Mike. Comparing the size with other properties is not part of
Okay.
Anything new?
Just with regard to the road abandonment, it did go before the planning board. I do have a copy of an agenda from March 11th, 2021, which I can submit, but I don't see that it's relevant to this board because this board is here for Chapter 325. we did reduce the scope of the project by taking the barn that was originally proposed. We reduced the size of the barn before the first hearing at the request of the neighbor prior to even coming before this board. Then we further reduced it by attaching it to the house. What else? We have been working to provide a maximized wetland buffer while still suiting the needs of the people who have to live here every single day. This lot is larger, as is evidenced by that map that was just up, than all of the other lots in this area, because it was a combination of one lot in the subdivision and two other lots that were really not a part of the subdivision, but were the lots. The lot that Mr. Walsh is referring to that had the beach that was to provide access for the other neighbors is actually the other lot that's owned by Mr. Hausman and his brother. That is not a beach. It's tidal wetlands. It's never a beach at this point. So the beach that Ms. Huffine is looking for access to is actually the county property, which is a lot within the subdivision. That was not the lot that was to be granted beach access from the CNRs.
Hi, Michael House. I just want to make one quick point too. The road. So my brother and I own this property here, and I own this property here, and part of Pearson Road that it goes between those two properties is all within the wetlands. It's all in the wetlands. And as far as access goes, I mean, anybody in our neighborhood is happy, like, they can walk across our property if they want to swim. I'm not restricting anybody's access, so.
Okay.
Just one last point with the abandonments of the road. They didn't really do anything but buy them actual road frontage because they had a pre-existing nonconformity for their existing house, and the proposed house is actually meeting that same setback. I think the deck is slightly encroaching, so it's really not giving them any great change. I don't know. So that's all. That's all I have to say.
Thank you, Daphne.
You're welcome.
Anybody else?
Is there anyone else who would like to speak on this application? Is there anyone on Zoom, Kevin?
Just to
Yeah,
double-
there is.
You did receive 2 letters by email today. I believe Karina did forward those to the board, just to note for the record.
Okay. So,
They're joining now.
okay.
Hello, can you see me?
Yes, go ahead.
Okay, great. Hi, my name is Shelley Lynch Sparks. I reside at 20 Pearson Road with Candace Huffine, and I just wanted to formally introduce myself to you all. I've been quietly attending every hearing thus far concerning 40 Pearson Road, and wanted to just let you know where I stand. I'm an interior designer with a really successful firm in Soho and the Hamptons by the name of Pikeman & Co. We design large commercial and residential projects on both the North and South Forks. I am very familiar with the building and permitting process within each town and have established relationships. And I work alongside reputable builders and architects such as Blaise McCoy, BMA Architecture, Seaford Construction, SBS Builders, Bellow Architecture, and it goes on and on. I am in the business of designing dream homes, and while I understand that this is the goal for the Housemans, I have learned in my career that not every property is able to withstand all of client desires. So just a few call outs on my end, like the issues with this plan do vary in great length, and I think as Mr. Walsh mentioned, we've watched a few of these, and there are a lot of practical things that are just being I don't want to say overlooked, but there are allowances that I'm assuming that are going to be made. And so just on our end, we really continue to express great concern just for our property flooding. Our property is at the lowest grade of Pearson Road and Fanning Road. It's where all of the other grades kind of come together. And by raising the grade, adding fill underneath the house, so close to our house, their house is now going to be set back 20 feet from ours to accommodate a buffer and the continuous structures that they would like to build. And just overall, after multiple meetings, it's clear that they're not leaving much room for plan alterations except for removing a barn and a few areas around the pool. And just, if you haven't gotten the chance, Teresa Mahar submitted a letter, and she's at 68 Fanning Road. She was actually out of town and unable to make this meeting, but I would urge you to read her letter before making any decisions. She's lived in the neighborhood for over 23 years, and she thoroughly explains what happened during Sandy and how it affected the neighborhood, the flooding, and her mother actually owned the property that was sold to Mr. Houseman. We are spending our savings retaining Michael Walsh to offer research into whether the Houseman's plans are compliant and legal. We're really concerned for our future if this plan is approved. Not just on a personal level, but just on a climatic level, sustainability, and frankly, we will outlive them. So it's something to be considered, and for a structure that's 300% larger than this small, beautiful neighborhood, after neighboring with them and seeing the amount of structures that have been built on this lot and how compliance and necessary permissions have been overlooked, we're really worried that once they do get approval for this plan and they continue to build without compliance, and I understand that there are special inspections that are going to occur throughout a project's lifespan, but once this project is completed, who's going to be stopping by continually to check on this compliance? And if our yard floods after a heavy rain or a nor'easter or a hurricane due to the amount of fill, structures, and the septic location, which also that area floods quite a bit, who's responsible? Is it you guys for granting the approval of these permits? Is it the civil engineer whose drawings showed that there would be a space where the water would go instead of a trench or the sand that's there to drain it properly? We're asking you all to examine all factors before making this decision. It's not just about the Houseman's future, it's also about the rest of the neighborhood and our future as well. And we have invested a great deal into our property and would appreciate your careful review and consideration. Thank you.
Anyone else on that?
Is there anyone else who would like to speak on this application? Kevin, there's no one else?
No one else on Zoom.
Okay.
Well, make a motion to close the public hearing.
Well, do we,
No one else to talk?
do we need to research any of those things that have come up?
I don't think there's anything further that has to be researched at this point.
Okay.
It's up to the board. Well, I mean, it's up to the board.
Well,
Jurisdictionally, I think, the only thing I would say,
It's up to you if you want to, if you're so inclined to issue an approval, just to maybe condition it upon the applicant submitting something as to whether subdivision approval was required from the planning board or waived or.
okay. Okay. The only other thing I can think of is the concern of floodwaters leaving their property and going to the property to the north. Perhaps you can speak to that, Daphne. Is it possible for water to be discharged from your client's property to the neighbor's property?
Can I just ask a question with regard to this potential conditioning this upon whether or not a subdivision was necessary? This board has issued permits on this property in the past. So I'm kind of confused why that would be necessary at this juncture. It seems kind of irrelevant to me. The town has issued multiple permits on this property over the years, so I don't understand why that would be necessary.
It's
a good point.
Drainage.
It's never been brought up before.
Hadn't been brought up before.
So that's, so I think Kelly is just saying, if you want to keep it clean, just have the planning board come back and say,
Right.
it's not necessary.
I mean, it
Or
could-
have them issue it, and it can be conditional on that. We can still make a decision, but conditional on that. And so,
Right.
because something has been brought up, I think we have to address it.
I mean, it could be as simple as a letter from the planning department staff saying, you don't need approval, I mean, whatever, just to make sure that you have some contact with, the planning department, just to make sure that, approval, whether it is or is not required.
Yeah, I don't think it's a big thing. I could be wrong though, but.
I don't know. Okay. Otherwise, to address runoff from this property to the neighbor's property, I don't see how that's going to be a factor here, where we're proposing brand-new structures that will have adequate drainage to contain all impervious surfaces in between the structures and the Huffine property will be a large pervious gravel driveway that would catch any potential pervious stormwater that would come from the property otherwise. And beyond the driveway, the Housemans are planning to plant some screening vegetation, which we're showing on the site plan here, that would further catch any other water coming from the property. I mean, I don't know that there's gonna be any issue. The sanitary is going to be minimally raised because the leaching components don't require a ton of fill in that area. We did relocate the sanitary slightly further away from them, which did push it slightly closer to the wetlands to accommodate their concerns. So, I mean, Mr. Walsh is talking about 9D. If we want to get really serious about that, there's a lot of things this board could ask us to do that would push this project much closer to the neighbor's property line. But we're not talking about that. So,
Okay.
Thank you.
Also, Harry, bringing up sanding, that wasn't the norm. As you said, you've never seen, such high tides from that. It doesn't mean we're not going to have more storms because of the climate changing and the earth warming up. But during that storm, I think many of us saw water in places that we never imagined, we would.
right now, there are no buffers on this property. There is no natural vegetation beyond the wetland boundary. There's a significant amount of structure and hardscape between the wetland boundary and where we're proposing development right now that will be removed and will be replaced with native plantings. So this is what this board looks for in a project. Everything will be upgraded to today's standards, will be FEMA compliant. I think we've met the conditions of Chapter 325 9D with everything that we've done on this property.
Thank you.
Thank you, Deb.
If the board needs no more information, is
Motion to close the public hearing.
Second.
all in favor?
Aye.
Opposed? Thank you.
Thank you very much.
Paperwork back, please. That was from something else. Keep that. No, I'm not opening the folder again.
Oh, nitrogen. Gas right there.
on, the next application is the new one, A022093. Andrea Lusso and Maria Stoyanova.
Oh, yeah, this is a new public hearing, and we do have affidavits of posting and mailing applying to the town code, so the board does have jurisdiction.
Thank you.
Good evening, Kevin Springer, Dynamic Legal, 61 Channing Cross, Hampton Bays, New York, 11946. I have what I assume is a nice application here, nothing too substantial.
That's what we like.
I'll try and keep it quick here. So we'll start with the pool, which we are at 78.5 feet from the wetland. Just so anybody's aware, part of that wetland is actually a dirt road that anywhere from 50 to 100 cars drive through every day, which makes it a little bit of an insinuating circumstance. I know that Marty has an issue with 78, and he wanted us to put the pool over in this area. First problem with this is that's not meeting our side yard setback. That's going to require a variance. Then, if we move it over even more, now we're stuck right in here. In Marty's last, I believe it was 15 Mill Pond, that pool was 70 feet. We have the pool itself is basically a lap pool. It's 12 by 30, 6.5 feet deep at the most. The buffer itself is almost 65% of the backyard in total. So I'm just, I know that in the past, somebody else had submitted an application on this, I'm not sure who that was, and there was some conversation about the sun and whatever, and moving the pool this way to get sun, but that's not the problem. The problem is that we're not gonna meet our setback. This is an R40 zoning, and we would need to go to the zoning board for that, which is what we're trying to avoid in the first place, to add another 8 months to this project. I don't know if Marty, he had mentioned something about this not being the same, or this wasn't being the same, but I'm really not, he can speak to that. Again, it's not a really large pool, and if we do, at this point, we're probably gonna have to shift it over a little bit more anyway, which is not going to increase or decrease the setback, it's just gonna slide over a couple feet. But putting it this way clearly restricts the patio that we have, that we're proposing, as to what, what Marty wants to put there. I don't know if there's really a whole lot. We're moving the shed, removing the shed, we're not moving it. And let's see, everything else is pretty conforming that I can think of. And I don't know if you have any questions.
The size of the patio looks like a pretty big patio to me.
Yeah, it's probably looks about 30 by 30, but if you put a 12 by 30 pool in there, could we cut it down a little bit? Probably, but, we do, you have to remember that here, because we don't want the patio going any closer to the wetland, we would like some room for some chaise lounges, but then any barbecues and whatnot, and tables for outside would go behind here. So that, I know it looks big, but once you put the pool in there, it's not as large as you would think it would be. It's not a whole lot of space to begin with. So there will be stuff stored on this patio, because we now no longer will have a shed.
I haven't seen, I should have seen the report, but I haven't. So the frame dwelling exists as it does right now, correct?
Say that again?
The house is
The hou-
there, and, yes.
The house is there right now?
Yes, the house has been there for,
Okay, and so is
34
the
years.
concrete apron outside of the garage?
yes.
Okay.
You know, the dry wells have not been moved, the pool equipment is being moved to, you know, which I believe Marty is where he would like it. And again, I mean, I don't know if he's, wants this particular planting thing, but that can be, you know, however he would like that, that's fine.
Yeah, I don't have a sketch from staff in the file, so it's kind of hard for us to know visually what staff has proposed, so.
There is a sketch in the file.
This is your sketch?
Yeah.
Tom,
Oh, okay.
look here.
Okay.
See,
All
why he
right,
wants
that's-
to change the orientation.
All right, now I see.
You see?
It just
Okay.
wasn't clear to me, excuse me.
Symmetrically, I mean, I don't, who wants to put a pool on the property line?
86, so you'd like the pool to come in about another 8 feet? If I'm
Well,
reading everything
Well,
correctly?
you asking me to go to the podium or speak from
Yes,
here? or-
yeah, yeah.
I don't know if
Have you-
Kevin's
have you
done
finished?
or what we're doing here.
Have you finished?
Well, once he's done, you can go up, I just wanted to.
Yeah, that's what I'm wondering.
I'll come back up, that's fine.
Okay.
Okay, all right, thank you. Good evening, Marty Shea, Chief Environmental Analyst for the town. This application is really a return of a prior application that went for the board, which sought approval for similar improvements, so that application had been withdrawn and essentially resubmitted again. There is a preliminary advisory report on file dated December 12th, 2022. Previously, when this application had come before the board, this board, in the interest of trying to be creative about possible ways to offset wetland impacts, had expressed a desire to see an IAOWTS installed on this property and had expressed that if that was offered, that could be looked at as partial mitigation for lesser wetland construction setbacks that were being sought. Both the applicant and I had expressed concern regarding that discussion, as I didn't see that it would be appropriate to require that an IA be installed as mitigation for a pool, because the benefits of the IA are not related well to impacts that are associated with pool construction. The consequence of installing that IA would also have been that the applicant would have had to cut and remove quite a number of large trees roadside of the dwelling, and neither the applicant nor I saw the environmental benefits of that at this site. So in communication with the applicant, I had agreed to work towards a alternate creative design plan for this site that could provide sufficient mitigation without having to revisit any requirement for IA installation. Obviously a pool is an amenity. That being said, when an applicant expresses a significant desire to install a pool, I try and do what I can to work with the applicant to find a way to get a pool. And what Chapter 325 directs us to do is to evaluate practicable alternatives wherein when the applicant is seeking relief from the required minimum wetland construction setbacks and natural buffer setbacks. As this is a developed property, the minimum required wetland building setback, of course, is 100 feet. The minimum buffer is 75 feet. This property, this plan falls significantly shy of those parameters. What Chapter 325 directs us to do is to see whether or not a different design approach could be taken that could increase the wetland setbacks and increase the opportunity for expanding the buffer. Initially, there seemed to be some interest on part of the applicant to work with me in that direction. But when the applicant came forward with this planting plan, and I had expressed to the applicant what I thought needed to be considered as an alternate plan, the applicant was not amenable to that. Mention was made of other applications, and I take the same approach with other applications. Look at the entirety of the property and look at whether or not there's an opportunity to shift the pool further landward, whether or not there's an opportunity to reduce the footprint of the pool, and whether or not there's an opportunity to maximize setbacks. So the sketch I provided dated August 5, 2021, of course shows a smaller pool, 10 by 20-foot pool, at a greater setback of 86 feet, with a shifted patio as well. While the pool is shown at 78.6 feet from the wetlands, the patio is 75 feet, so the patio is closer. If you know these wetlands, they're very significant. Yes, the property is separated by a very narrow, muddy, private road that's often underwater, that separates this property from the vegetated wetlands. If you visit this waterway frequently, as I do, you'll see that it's an area of abundant wildlife. It's an area where you see herons, egrets. It's a quiet area, so you got waterfowl that resides in that area. This area flows out into Smith Creek in the greater Shinnecock Bay. So we have to be very cautious about protecting this area, particularly in light of the history of this area, wherein the watershed for the system was heavily impacted by development. So as new plans come forward, we ask landowners to appreciate the proximate wetland resources and work with my office to try and become a good environmental steward of the area, and to do what they can to try and consider other approaches or designs in order to increase the setbacks. Notwithstanding my belief that the footprint of the pool could be reduced and the pool could be shifted further landward, even in the event that variances may be needed, the applicant has no interest in coming forward with an alternative design that reduces the scale of this activity, and they are proposing a very large patio on top of a significantly sized pool. I think what the applicant needs to do is consider further expanding the buffer. That'll help better mitigate the impacts of the construction. And what are those effects? One of the great concerns with pool and patio areas is that these are areas where you have exterior human activity, and that activity stresses and affects wildlife in proximate areas. In fact, if you look at much of the research that was done, the closer the activity is to wildlife, the less productive wildlife are with regards to breeding and living out their biology. Songbird, the success rates of songbird nesting is less. And so, it's a little bit different with the house because the area is enclosed, but when we have these exterior areas, number one, we try and get them as far away from areas that are important for wetland dependent wildlife, so that the habitat area is more functional. And the second part of that is to try and expand the buffer as much as possible. So again, hearing that the applicant has no interest in either reducing the scale of their construction or looking to shift the pool further away in a manner that would be more consistent with the setback parameters set forth by the board, I would ask that the applicant consider further expansion of the buffer to lessen the impacts of this plan. Thank you.
Thank you, Marty.
Okay. As far as the wetlands themselves, as I mentioned, in reality, the easiest way to get through that is close the road. But you can't do that. So this pool is not the main effect on the wildlife or the wetlands in that area. Again, Marty keeps coming back to this, but he's proposing it for me to put it in where I can't even without a variance. It's not in the right spot. It's a 20-foot setback. He's got me at 10 feet. If that's shoved all the way over here, then I'm gonna be here, and this is gonna change minimal at best. So we go from what, maybe 78 to 80? And it's not that I won't work with Marty, but I wanted to come here, propose what we have, get your feeling, and then, take the next step. But this was the big issue, and this does not work, and just doesn't work. I don't know how else to put it, to be honest with you.
Doesn't work because it forces you to go to ZBA for a variance, or what is the reason why it doesn't work?
Well, it doesn't, because the way he wants it, he's immediately putting you into the zoning board. It doesn't meet code, period.
Right, but that doesn't exclude us from issuing
No,
a
I
permit that way.
understand
The
that.
zoning board often looks at our reasoning when
No,
they issue variances.
that I
So
understand.
it's not mutually exclusive.
But if we were to move this, and again, we're open to some suggestions, I'm just, I don't know what he wants me to do, is to build a 12 by 10 pool, but, it's already, again, it's basically a lap pool. We're not building this huge pool that's 8 feet deep and, 20 by 40.
Have you seen Marty's drawing?
Yeah, Marty's drawing isn't, it's not 80 feet, he shows it at 80.
Yeah, he's got it as a 10 by
80
20.
86.
Yes, and it's an 86-foot
So-
setback.
Yes, but if you, that's an even smaller pool. That's a 10 by 20 pool. That's barely a pool. That's almost the size of a hot tub. And again, I'm not saying I can't or won't change the size of the pool, but moving it over to here and then cutting at least 30% of the pool out, well, that doesn't seem reasonable either.
What about the possibility of moving the entire pool down? Which direction is that? South?
South.
Well, that was my next point. So, as you can see here, we are already going to have to move it 5 feet. Because on this drawing and on the survey that you have, it's at 15 feet. So in order to avoid, we have a 20-foot setback. So that's already gonna have to be shifted towards the south, 5 feet. Which can either be done by taking a couple of feet off and sliding it, or sliding the whole pool. There are options, but, go to a 10 by 20. I mean, the neighbor down the road, last year, you gave him a much larger pool, 3 doors down. And both neighbors to the south, now I understand, let me just preface this with the fact that they both have pools, but they were built before conservation. One of them has no buffer and is 55 feet from the wetlands. The other one is about 20 feet from the wetlands. So as far as the neighborhood goes, and, you know, I don't know how much more backyard we're gonna give them. 65% is considerably a lot if you look at this. I mean, I don't think we're being unreasonable. But again, I'm not saying I'm not open to suggestions with Marty. I just wanted to show you what we were thinking and to get your thoughts.
Okay, so you're open to moving the pool south?
Well,
south?
it's gonna have to move south, and because we don't all have room, the thought is that we would probably take about 2 feet off of here already anyway, so that makes it a 12 by 28. And it's still gonna have to get shifted a couple of feet just to meet this setback to not have.
Pardon me, when you say south, you mean to the left as we're looking at
Yes,
that
to the
drawing?
left. This is the
Okay.
south here, west, and east. So this whole thing has to be shifted.
So you can move it 3 feet to the left and take
And
2
cut
feet
off
off,
2 feet of
and then you'll be in compliance at 20 feet.
With the building department, yes.
Is there room to move it down?
So you were gonna say this way. I
Because-
have to get, which I don't have, I don't know why he didn't put it on here, but I have to, all I really need, I'm not saying I'm not, but I need to get this dimension here from here to here, from the pool to the house. And then I
So
can,
Marty's drawing shows a 10 by 20-foot pool with an 86-foot setback. Essentially, that increase in setback from your drawing of something a little bit less than 78 is, the increase in setback is because the pool is made shorter. So if you want the longer pool for a lap pool, then leave it in the same orientation, but pull it closer downward.
okay, so when you say downward, are you, you're
Down,
saying to the
yes.
house?
Down, because,
Well-
because really it's south, you need to move it southwest.
Well, this is south.
Yeah, well,
this
south is,
This is a no-brainer here. This going south, this end of the pool, there's no choice but to move it, or else we're gonna have to cut off
Yeah.
5 feet of pool, you know.
I'm
that
guesstimating
gives
from
you, that
pool to
gets
the
you in
garage is about
compliance
11,
with the
12
zoning
feet.
code.
Yes, correct.
But to get you more in compliance with our code, move it straight down, and then every foot you move it down is another foot of separation from the wetland.
Well,
The code calls for 100 feet, you can't do 100 feet. but
no,
you
I
can-
understand, but, and that I understand, but I'm thinking if we make it an even 80 feet, you know, we just spoke about the one on 15 Mill Pond, that's at 70 feet, and that pool was bigger than this pool.
We
So I'm
can't,
just-
we can't make comparisons.
I understand,
you know,
and
on the
there are-
fly with other properties, you really can't.
So I think what's best is for you to play around with this, get some measurements you need to look at, and see how you can come up with a pool that you want that does a better job of meeting the chapter 325 standards. I can't see exactly what that's gonna be right now,
No, I understand that.
but you might very well be able to achieve the 86-foot setback that Marty has achieved with his reoriented
Well-
pool.
Let me go back to that though. So right now, this is at 78. To get to 86, you're talking 9 feet. That's gonna come all the way down to here, and then we're gonna have no patio.
And the
So-
pool is gonna be in the shade.
Yeah, and then the pool now the pool gets stuck behind this part of the house again. We're back to square one, where this whole part of the house is blocking. Because this is a 2-story house also. So if you see, the more I pull this down, this part of the house, which is 2-story, this is now gonna start blocking here. We're keeping all the natural trees, which are large oaks, plus all the vegetation. I mean, it's just not practical,
So-
per se.
So.
To bring it is where you're asking for, is what I'm saying. I'm not saying we can't move it down, I'm just saying if we move it 9 feet,
8 feet.
It'll still be in the shade.
it's still, it's still right out the back door. What my thought is I'd like to get this dimension here, from the pool to here, and see how much room I have here, so I can play with this number here.
Okay.
Good.
Will that work for you?
Yes.
That's what you need to do, yes, Marty.
Sorry.
Marty Shea, Chief Environmental Analyst for the town. I thought it would be helpful to explain to the board why I reoriented the pool the way I did. When the applicant had previously come forward, and I was looking for the applicant to consider a similar thing to what you're asking, the applicant had expressed a lot of concern about the pool potentially being shaded by the second floor section of the house. So one of the things that I did is I went to this property on the shortest day of the year, last December, and went at midday, about 11:30, when the sun was directly behind the highest peak of the house, to look at the shading that was occurring in the yard. And I found, although the sun is at its lowest on the shortest day of the year, and there's the greatest potential when it's directly behind the peak of the house, I found that very little, if any, of the footprint that I drew would be shaded. So that was drawn in direct response to prior concerns raised by the applicant regarding shading. The second comment I wanted to make is the applicant had generally expressed that this property is in the midst of non-conforming or uncompatible residences. Yes, he did express that many of those residences and pools were built prior to the effective date of Chapter 325. But I should mention, the house to the immediate north is fully compliant. It was built 125 feet back from wetlands. Its buffer is 100 feet. If you look at the aerial, Karina, if you could just bring up the aerial for a minute. If you look at the house immediately north, you see that the woody vegetation comes very close up to the house because they had to comply with the minimum required 100-foot setback, because this was vacant land when Chapter 325 was adopted. So they had to come in with a strictly conforming plan, which they did. They came back at one point in time to see if they could put a pool on this property, and they were denied the ability to put a pool on the property because they couldn't conform with that still required 125-foot setback. So there are residences in the area that have no ability to put a pool on their property. That being said, what I think is needed here is, as was alluded to, I think what the applicant needs to do is they need to go back to the drawing board and see what can be done to reduce the footprint of the patio and the pool, to see if there's an opportunity to lessen the coverage, to increase the structural setbacks, not necessarily maximize it, not necessarily consistent with what I drew, but any change that would significantly increase the setbacks would be beneficial. And part of that exercise could also be looking at whether or not there would be amenable to further increasing the buffer. The reason the buffer is drawn the way it is because I had suggested that the northern portion of the buffer tie in with the covenanted buffer on the adjacent property, which it just about does. But there may be an opportunity to further expand the buffer in the rest of the property. So I think the applicant received some good guidance from this board. The applicant also expressed that we needed to take a close look at setbacks from the house and what alternative approaches might work, and I'm happy to work with the applicant in considering alternative drawings. Thank you.
Okay, so, as I had mentioned before, that's, we're gonna play with this a little bit, see what we can come up with, and, come back to you.
Thank you. Is there anyone in the public who'd like to speak on this application? Anyone on Zoom?
We're either the 14th or the 28th of June. 28th preferable.
How much time do you need?
First available one would be wonderful, because I'll have this hopefully squared away.
Nothing earlier than June 14th, but June 28th only has one person.
June
on it.
14th?
June 14th it is.
Motion to adjourn to June 14th, 2023.
Second.
All in favor? Aye. Opposed? Thank you. Advisory reports, 325 Rose Hill Road.
Good evening, again, Marty Shea, Chief Environmental Analyst for the town. It's a pending subdivision for a property that was marked by a large covenant for many years, and the applicant is seeking to subdivide this, take the covenant down and subdivide the convent down and subdivide the property into 2 lots. A lot of local neighborhood concern about its application. So the subdivision is in its final stages. There are several recommended comments. First is that the tract where the 2-lot subdivision is being proposed fronts on Hayground Cove, which is the largest tributary to Mecox Bay and of great ecological value to the town. Quality of these estuarine surface waters have been adversely affected by historic upland development patterns, which have led to Mecox Bay being designated as a New York State DEC pathogen impacted water body. As such, every effort needs to be made to avoid further adverse environmental impact as a consequence of redevelopment. Second, as the tract contains town regulated wetlands, in section 292-39B, referral is required. Thirdly, consistent with this board's prior advisory report dated July 28, 2021, the existing scenic and conservation easement needs to be expanded to cover all portions of the parcel within 100 feet of the wetlands boundary. That's to protect and enhance wetland values. Fourth, as also noted by such report, portions of the easement as well as a recommended expanded buffer were previously cleared and disturbed. As such, the applicant needs to submit a native revegetation and restoration plan, both the existing and recommended expanded easement. If necessary, the Environment Division can provide further reclamation guidance inclusive of a native plant list. 5, in order to ensure the wetlands are adequately protected in the long term, a notice covenant needs to be filed advising future landowners of both parcels that the lots contain town regulated wetlands and that town wetland permits may be required for any land disturbance or future construction. 6, any subdivision approval needs to be conditioned upon the establishment of one shared common elevated light penetrable deck, maximum 4 feet wide dock, supported by untreated posts with allowance for a maximum 4 feet wide pervious pedestrian path located within the bounds of the existing 30-foot legal access strip to Hayground Cove. And that summarizes comments, recommended comments at this time.
Motion to send these comments to the planning board?
Second.
All in favor?
Aye.
Opposed? Canal, Southampton Battery Storage.
This is a pending site plan application for a battery storage facility in Hampton Bays. There are several recommended comments. The first is that an existing single-family ranch and 4 cottages would be demolished in order to allow for construction of the battery and energy storage system consisting of auxiliary power stations, power convert systems, lithium-ion battery units atop concrete pads, switchgear, maintenance driveway, and leachate/drainage basins with utility lines to be directionally drilled under the Sunrise Highway, North Road, Law Board Road interchange in order to connect to the existing PSCG substation to the east. 4.39 acres of land, which would be affected by the project, were formerly forested with pitch pine, but have been heavily impacted by southern pine beetle, leaving only a few remnant healthy mature pine trees along North Road. 2, despite the abundance of fallen and standing dead trees, there is considerable indigenous coastal pine barrens, vegetative ground cover, and some scattered oaks and sassafras, as well as Pennsylvania sedge, black huckleberry, bayberry, black cherry, and green briar, with very few invasives observed. 3, the project site is located within a high fire risk region of the town due to the abundant natural fuel loads present in this portion of Hampton Bays as a consequence of southern pine beetle. Therefore, in view of the abutting highway, arterial roads, and proximate residential neighborhoods, as well as potential for soil and water contamination, emergency fire response and suppression plans need to be prepared. 4, the winterberry holly plantings, which are proposed for installation alongside the eastern red cedar, should be substituted with native evergreen inkberry, as the latter plant is likely to be more tolerant of road soil. 5, as the planned action would entail disturbance greater than 1 acre, a SWIP application needs to be filed with the town engineer's office.
So we can send those comments to the planning board?
Yeah, wait, just before
Oh,
you do,
excuse me.
I just wanted to, I'm sorry, I wanted to say something. The site that they want to put this storage unit, do you have any, I mean, I have some concerns. People are very worried about the fires and where this area is because of the pines and the trees and where it's located. Is there any way to suggest that they might look for a better place? I don't know if there's a better place. You know, many people have a lot of concerns, you know, over these units. You know, and the fires, and they're very, you know, very hard to put out and where they are. And that's an area that if we are in a drought, you have to worry about fires anyway.
I know that in light of those concerns, there's been some discussion about whether to institute a moratorium on additional applications. I don't know what the status of that is at the town board
I can
level.
check on that, I'm not sure.
The second site they were looking at was a forested site in Hampton Bays on Montauk Highway.
Right.
It's also pine dominated forest with abundant tree debris and a lot of you know, high fuel loads, and there are similar concerns with that site. But yeah, this area in particular was one of the areas of the town that was hit the hardest by southern pine beetle. So you look at virtually all the surrounding areas going through the eastern Hampton Bays going into Shinnecock Hills, and there are abundant dead pines in that area. So a suggestion can be made as an amendment to this advisory report if you want.
Okay.
Do you know if that plan calls for the removal of those trees, the dead trees?
Yes, the majority of the site would be bulldozed and developed, but that being said, the surrounding areas are still marked by very abundant dead trees, standing and fallen dead trees. Plus, you've got North Road on the west side. You've got the entrance and exit to Sunrise Highway on the south side, and you've got Sunrise Highway to the north. The railroad is pretty close to the south, so it's right in the midst of heavily traveled arteries and highways, which raises additional concern in the light of fire.
Marty, is this a town project or a private project?
No, it's private.
Private.
Private?
PSCG.
One of the reasons this site was chosen, though, is because they need to connect into substations. And you have the large PSCG substation on the south side of Sunrise Highway that they would directionally drill to in order to use this site. So that's one of the criteria. They need to find locations that are in close proximity to substations. But that, I'm happy to make that suggestion.
In response to Tom's motion,
So there's no call for solar here. Trying to figure out what they're doing here.
It's what a battery facility does, it stores energy.
Yes.
So one of the main goals of these facilities is energy conservation.
They're gonna store
So
energy
they store it that it's siphoned off of the substation that they want to connect to.
during
It's
one part of the
not- it's not
day to
generating-
release it another part of the day.
Yeah, anything that's not otherwise in demand, it'll be siphoned to battery storage, and over time, those batteries will be kept at a certain level.
Okay,
But it's not generating its own power by means of solar or.
right.
So that you're not losing any of your
Hamsters
energy,
or
you're
whatever
storing
else.
that energy.
Right.
All right, is there a motion to?
I gave a motion.
gave a
already.
motion.
No
I'm
one-
seconding it.
All in favor?
Aye.
Opposed? Old Stables at Spionk.
This is a pending subdivision in its final stages. There are several recommended comments. First is that the planned density incentive subdivision would affect the forested block and county map watershed lands for Seatuck Cove. These woods are vital for protecting water quality and replenishing groundwater. They also aid in cleaning the air through carbon sequestration and help to sustain local floral and faunal biodiversity. 2, clearance standards should thus be adhered to, with allowable site disturbance limited to 60% on lots 1 and 4 and 50% on lots 2 and 3. Thirdly, the Conservation Board supports establishment of open space within the westerly part of the tract, where the protected woods would link with town preserved lands to the north. 4, consistent with the Conservation Board's prior advisory reports of 2015 and 2020, subdivision map has been revised to depict all trees with a DBH of 24 inches or greater within those portions of the tract to be developed. Trees outside of the building envelopes need to be preserved to the maximum extent practicable. 5, the planned open space should be demarcated with split rail fences rather than partial post and wire fences to lessen interference with wild animal movement and risk of wildlife injury. And 6, the tract is located within a mile and a half of documented summer occurrences of federally endangered northern long-eared bat. As such, the applicant needs to contact the DEC for guidance on tree removal and any other habitat protection measures that need to be adhered to. Any special requirements as established by the DEC need to be noted on the subdivision map.
Move to send these comments to the planning board?
Second?
All in favor?
Aye.
Opposed? For the ZBA 61 Bayview Drive, LLC.
This is a lot line modification that's pending before the planning board. That's also before the ZBA. There are several recommended comments. For the first comment indicates that the parcels for which lot area, lot width, and property line setback variances are being sought front on Little Peconic Bay contain extensive interconnected freshwater and tidal wetlands, which are regulated by both the town and the state. Second, the Conservation Board supports the transfer of approximately 7,656 square feet of land from Lot 1, known as 61 Bayview Drive, to Lot 2, which is 65 Bayview Drive, as the lot line modification would allow for elevation and retreat of the bayfront in residence. thereby bettering coastal resiliency and compatibility with FEMA standards. However, the Conservation Board has significant concerns regarding the proposed redevelopment of Lot 2. Thirdly, in the interest of lessening potential adverse environmental impacts and the risk of future storm and flood damage, the project plans need to be revised to reduce the footprint and coverage of the proposed new residence and to eliminate the planned swimming pool, both of which are being proposed less than 10 feet from wetlands, where a minimum structural setback of 100 feet is required by code. 4, scaling back of the residential development plans will allow for establishment of a critically needed covenanted wetland preservation area, naturally vegetated wetland non-disturbance, non-fertilization buffer. And lastly, the use of shallow distribution trenches in lieu of leaching galleys also needs to be explored in order to minimize the deposition of fill, which can alter drainage patterns and unnaturally displace floodwaters onto other proximate residentially developed properties.
Excuse me, has this, have they had an application before us?
Now, we had this is a lot line modification before the planning board, and because part of the lot line modification is a proposal to construct a new home, we had recommended that the planning board defer wetland permitting to this board for the purposes of residential development. They decided not to do that. So the residential development plans being reviewed by the planning board as a site plan application.
So it will not come before us?
No.
Well then, I'm sorry, Marty, I'm a little confused. You're talking about a swimming pool being proposed less than 10 feet from wetlands? And that's gonna be approved?
Well, I don't know if it's going to be approved, just that the planning board decided that because the planned residential redevelopment is closely associated with the lot line modification, that they should be using their powers to require submittal of a site plan application in order to consider the residential development.
But these comments are addressed to the zoning board. of
Well, yeah,
appeals.
I was just going to say that, thank you. This is not actually the planning board application I'm looking at tonight. This is the zoning board application as indicated in the first comment. The residential redevelopment plans require lot area, lot width, and property line setback variances. So before the planning board can move forward with finalizing the lot line modifications and the site plan, the landowner was directed to go to the zoning board to see if they could get the relief that's necessary.
Is it possible to put a comment in here that we strongly suggest that they come before us with for a wetland application?
Well, I can certainly do that, but we did
I know
make
you did that once,
recommendation previously in response to the planning board application. And I also was very involved in pre-application meetings with the applicant, their consultants, their attorney, and planning staff, wherein I made that recommendation as well. And it was basically ignored. So. But this would not be the appropriate time to make that recommendation, because at this time, you're responding to an advisory referral from the zoning board rather than the planning board.
Okay.
Planning board application will come back to you.
Thank you.
You're welcome.
Move to send these comments to the ZBA.
Second.
All in favor? Aye. Opposed? And for the Board of Trustees of the Freeholders and commonality of the town of Southampton. David Silverstein. I don't have that one in my packet.
I don't have it, I don't see it.
Do I?
That was in.
Oh, okay.
It's at the end?
No, we put it on last minute, so it might not have.
So why don't we,
Do you have it on your computer?
I could put it.
Not on the screen.
Yeah.
so the Board of Trustees had referred a pending application for a property on Waters Edge Road in North Sea, where the landowner had installed a bulkhead along a naturally vegetated shoreline of Fish Cove without permits from either the trustees or this board. This initially came to our attention when a prior application was made to this board to get approval to construct residential additions. I had inspected the property at that time, saw the unauthorized bulkhead, reported it to the trustees.
That's good.
In response to citations, the landowner had made an application to the trustees to legalize the bulkhead, and the application was denied, and this board had supported that denial. The landowner was told that the bulkhead needed to be wholly removed and the shoreline reclaimed. They never did it. And so I don't know if the ownership has changed since then, but the current owner is going back to the board to get the board to reconsider that denial to see if they can keep that bulkhead. I went to the property yesterday, and nothing has changed about this property that would warrant legalizing that bulkhead. This property is in a very sheltered location, so there's no wave action, there's no potential for wind-generated erosion. All the surrounding properties are naturally vegetated at the shoreline. So the advisory report that Karina put on the screen here recommends that the application be denied again.
You know, Marty,
And that the shoreline be fully restored. Landowner has also been cited for illegal construction activities associated with the residents as well. They got a stop work order for that. The house is just sitting. They haven't started working again.
Marty, if they determine something is illegal, is there any kind of documentation that goes with that? I mean, would that get past the title search, Tom?
I don't know, I'm not a title person.
Yeah. Come on.
Well, the title search would
Realtors know more about that.
result in a finding of the existing citations. So likely, I would assume that. So, you know, this property's been in violation for many years. So, you know, as indicated, they were directed to remove the bulkhead and reclaim the shoreline. And I think the trustees recommended that they work with me on the reclamation plan. It was never done, so now they're going back to them again and asking them to reconsider.
I want to visit that property.
So the advisory report is written, say that the circumstances haven't changed, and there's no need for shore armoring in this protected cove area, and it goes on to support the denial of the application and removal of the bulkhead again.
You visited the property. Is it the last house? Is there a house further beyond that towards the water, or is it by itself?
Water's Edge, you have like, you know, a string of houses along the water. Robbins Lane is just to the south of this property. one residence over.
It's like this.
Okay, that's not,
Okay, so-
all right, thank God. It's not the house next door, thank God.
Is there a motion to send these comments to
So
the
moved.
trustees?
Second.
All in favor?
Aye.
Opposed? The administrative wetland permits are in your packets. Resolution of conditional approval, A 022019, Doreen Grigo. Any discussion?
Move to issue.
Second.
Resolved that a conditional wetland permit approval be granted to Doreen Grigo for the proposed project upon its terms and conditions set forth therein. All in favor?
Aye.
Opposed? A 023003, 46 Oakhurst Road LLC. Any discussion?
Move to issue.
Second.
Resolved that a conditional wetland permit approval be granted to 46 Oakhurst Road LLC for the proposed project upon the terms and conditions set forth therein. All in favor?
Aye.
Opposed? A 022028, Denise Sokolich.
Motion to,
Go ahead.
motion to postpone to May 10th, 2023.
Second.
All in favor?
Aye.
Opposed? A 022087, Linda Perillo. Any discussion?
Move to issue.
Resolved that a conditional wetland permit approval be granted to Linda Perillo for the proposed project on the terms and conditions set forth therein. All in favor?
Aye.
Opposed? A 023010, Margot Carr and Dana Robinson. Any discussion?
Move to issue.
Second.
Resolved that a conditional wetland permit approval granted to Margot Carr and Dana Robinson for the proposed project on the terms and conditions set forth therein. All in favor?
Aye.
Opposed? A 023018, Linda Corso and Clifford Dean Corso. Any discussion?
Move to issue.
Second.
Resolved that a conditional wetland permit approval granted to Linda Corso and Clifford Dean Corso for the proposed project upon the terms and conditions set forth therein. All in favor?
Aye.
Opposed? Preliminary review of secret determination, A 021076, Nicholas Christopher and Penelope Christopher.
Motion to postpone to May 10th, 2023.
Second.
All in favor?
Aye.
Opposed? A 022012, Duretti Pupa.
Motion to postpone to May 10th.
Second.
All in favor?
Aye.
Opposed? A 022058, Francis Torres and Yvonne Torres.
This application relates to an existing residentially developed property on Round Pond Lane in the hamlet of Sag Harbor. Property has frontage on state and town regulated freshwater wetlands. There are activities that need to be legalized. We're also looking to construct residential additions. There is a preliminary advisory report on file dated April 24, 2023. When I visited the property, I found that property was not in compliance with an existing covenanted buffer due to clearing, landscaping, and fencing, and that it was also not in compliance with the Aquifer Protection Overlay District clearing standards. So my office has been working with the applicants to come forward with a plan to restore and expand upon the existing covenanted buffers and to bring this property into compliance with the natural vegetation protection standards. We're close to a final plan for this property. Part of that plan would be to relocate the existing unauthorized hot tub on the property to get it further away from the water, as well as to allow for installation of an IA OWTS. There is sufficient information to make a determination. As such, we're recommending that the hearing requirement be waived.
Motion to waive the public hearing?
Second.
Resolved that the Town Conservation Board hereby waives the public hearing requirement pursuant to Chapter 325, Section 325-80 of the Town Code. All in favor?
Aye.
Opposed? A 022082, Erlinda Bildner.
Motion to postpone to May 10th?
Second.
All in favor?
Aye.
Opposed? A 022092, Scott Levinson.
This application relates to an existing residentially developed property in the central Pine Barrens, adjacent to a shrub swamp and regulated freshwater wetlands. The applicant needs to legalize various decks. They're looking to construct a second-story addition to the existing dwelling. porch and rooftop deck. They want to install a swimming pool, deck area. They would also be upgrading the sanitary system. We have been working closely with the landowner to try and produce a conforming plan for the property. The current proposal and recommendation would entail establishing a covenanted natural vegetative buffer, taking in those portions of the property within 75 feet of the adjacent wetlands. Establishment of that buffer will entail removal of hardscape improvements such as a arbor, ornamental pond, gravel patio area, frame shed, and fences. The pool is going to be structurally elevated in order to provide sufficient vertical separation from the shallow groundwater in this area. We are also working closely with the applicant on a restoration plan for the buffer using indigenous pine barrens vegetation. There is sufficient information in order to make a determination. As such, I'm recommending that the public hearing requirement be waived.
Motion to waive public hearing?
Second. Resolved that the Town Conservation Board hereby waives the public hearing requirement pursuant to Chapter 25, Section 325-80 of the Town Code. All in favor?
Aye.
Opposed? Code Interpretation Amendment A 02209591 Cobile LLC.
This application was made to the board in order to work with my office in order to develop a plan for conservation and management measures within an existing covenanted buffer that was required by this board in order to better protect the ecological integrity of the area in order to counter some of the invasive plants that are colonizing the site. In response to this board's requirements of a prior permit, the applicant had done very extensive native planting. Some of that vegetation is being choked out by Phragmites and other invasive weeds. I did have an opportunity to meet with the landowner and the caretaker, and there's been quite a lot of communication back and forth between me, with the owner and caretaker, and with their attorney, as well as InterScience, resulting in a final conservation and management plan. In order to allow for the conservation and management measures, the language of the existing covenant would need to be amended. So the applicant will come forward with a survey detailing the permissible conservation and management measures, and then a covenant will be drafted for review by the town attorney's office. One of the things that the covenant will also do is when the board had previously required the covenant, the restricted area is brought right up to the residence, the walls of the residence, and the landowner needs to have safe access around the exterior of the residence. So the plan does include a 5-foot grassed pathway around the house.
Is there a motion? This is a change in covenant, so we need majority plus one, which is 5 out of 6 of our votes for tonight. And just scroll down the last little bit for the resolution. What was that?
Motion hereby waives the
Well,
public.
we're,
So right now, we're just looking at, I'm sorry. Right now, the resolution before you is simply to waive the hearing because the conservation management measures are being authorized and the existing covenant is being amended through the wetland permit application process. So at this stage,
okay, it's going to come
there's a
back to us
recommendation
later.
to waive the hearing
Okay.
because we do have sufficient information to go forward with this application. But when it comes before you for conditional approval, we will need a majority plus one vote of approval in order to issue a permit allowing for these covenant changes.
Motion to waive the public hearing?
Second?
Resolved that the Town Conservation Board hereby waives the public hearing requirement pursuant to Chapter 325, Section 325-80 of the Town Code. All in favor?
Aye.
Opposed?
Motion to adjourn.
Second.
All in favor?
Aye.
Opposed? Thank you all.
You've got a name sign.
I know.
It's not paper anymore.
Is it the same font as the rest of them, or?
No, it's not. You have
little
you have your
Yeah, I got
own
it.
font.
Yours is special.
Yeah.
It's
It's
a new
finer
upgraded
and
version.
class. It's classier than the.
Whoa, this guy stands out here.
It's classier than the
Well,
courier.
he's got
the
pull. I know he's
Courier
got
new
pull.
that everybody else gets.
Good night, all.
Take care.